All right, we're going to get underway with our breakout session entitled Clinical and Legal Collaboration in Mental Health Litigation, the Civil Commitment Process. This presentation is going to offer an in-depth exploration of the intersection between clinical expertise and legal frameworks in civil commitment cases. You will gain an understanding of the clinical assessments and legal criteria that guide commitment decisions, the challenges in balancing patient rights with public safety, and the procedures involved in performing a civil commitment. We have two terrific speakers for us here today. Daniela Chisolm is a senior trial attorney with the El Paso County Attorney's Office Mental Health Unit. And Dr. Roberto Kutcher-Diaz is Psychiatry Fellow at Texas Tech University Health Sciences Center, El Paso. Welcome, Ms. Chisolm and Dr. Kutcher-Diaz.
Good morning, everyone. Thank you so much for being here and joining our session. My name is Daniela Chisolm. I'm an assistant county attorney with the El Paso County Attorney's Office in the Mental Health Litigation Unit. What I do on a day-to-day basis is I do the civil commitment hearings, and also I train local stakeholders in the commitment process, law enforcement, our physicians at our emergency rooms, our community members. And one of the best parts of what I do is I train and work closely with our psychiatry residents at our local medical school in El Paso. And I'm really happy to have my co-presenter here today. Normally, I do the legal walkthrough on the civil commitment process, which is good. I enjoy. It's what I love to do. But I thought about something different for this audience. Normally, we just hear from the lawyers and we run through the law together. But this time, I want to give a behind-the-curtains view of what's happening on the clinical side as we're walking through these legal process. So with Dr. Kutcher-Diaz, he is one of our fellows we have in El Paso. And for anybody who's not aware of how the system works, is someone's got to go to medical school for 4 years, and then they pick what kind of residency program they would like to go into. For Dr. Kutcher-Diaz, he was in the psychiatry residency program. You do that for 4 years, and then you have an opportunity to further and have a fellowship for 2 years or 1 year, depending on what specialty you want to go into. Right now, Dr. Kutcher, and he'll tell you a bit more about it, is with the Child and Adolescent Fellowship. And we've worked closely and presented together, and just very happy to have him go behind the curtain with you all today as we walk through the legal process.
Good morning, everyone. Thank you so much. My name is Dr. Kutcher-Diaz, and as Ms. Chisolm said, I'm a first-year child and adolescent psychiatry fellow. A little bit about myself: I was born and raised in San Juan, Puerto Rico. I did my undergrad at UC Santa Barbara. After that, I finished my master's in public health in Puerto Rico before going into medical school. After medical school, I came to El Paso to do my psychiatry residency. That's where I first had my experience with the legal process in mental health, which is something that I knew nothing about before even going into residency. I mean, I'd heard some aspects about it, but never had any firsthand experience. So it's been, really a process that's made me grow a lot, and I think is essential for every single program. And I'll go into the reasons why that's important. And so throughout my time here, I've also gone to different conferences talking about this, specific area, because again, it's something that I'm very much passionate about. And in 2023, I actually went to the Texas Capitol and advocated for the definition of psychiatrist to include psychiatry residents. Because again, I think that this is an essential part of training that needs to be included specifically for psychiatrists, especially, people that are in this particular phase. I can't imagine going 4 years of residency, having never set foot in a courtroom, and then all of a sudden I'm thrown to the wolves, right? So hopefully that's something that I would like to prevent for all residents. So I'll let Ms. Chisolm take it away.
And today, as we walk through the legal process, some of you may be familiar with the different processes we have, but we're going to do a general overview as step by step so it's easy to digest what happens when someone is in a civil commitment and what is happening with the doctor and at that time their patient as we're walking through the civil commitment process. There's two types of civil commitments we have, outpatient and inpatient. Today we're really going to focus on the inpatient setting. And we're breaking it down into the different steps of what's happening with an individual, a community member, when they may need to have this legal mechanism and what's going on the clinical side. So we've got our emergency detention order, our EDOs, the various types of them that we'll walk through. I think El Paso is the only place that calls it a PCO. Everywhere in Texas, an OPC. And then we have our actual final commitment if we do have a community member that does need to be formally committed for up to 45, 90 days. So starting with our emergency detention orders, we've got a few different groups of people who can apply and who can use this legal mechanism of emergency detention order. Starting with on the right side, we group together our physicians, and Dr. Kutcher-Diaz will share his perspective on that as well. And we have adults in the community who are able to apply for these emergency detention orders. These two groups are held together because they have to go through a judicial screening process, meaning that it is not something that can be done without a warrant. They do need to submit the information for a judge to review, for that to be accepted, a warrant to be issued, a warrant to be executed for this legal mechanism. We, on the other hand, we do have for peace officers here in Texas, warrantless apprehension, where they are able to rely on hearsay and they are able to not have to utilize a judicial screening process in order to place somebody under a notification of detention. So what we're looking at here with an EDO is we're looking at a couple legal elements that have to be met. On the legal side, we're going to have a mental illness. There's a definition for that. And really, we're looking at what is the risk of harm to self, to others, or maybe at both, depending on what may be happening with this individual in this moment in time. We have here in Texas an area of the statute that allows for deterioration, meaning that somebody is unable to take care of their basic needs and does need to have some assistance with having some involuntary treatment. So the code gives us what is a mental illness defined. I'll let you all see it in here on the screen here. But more importantly is what does it not include? And so there's some clarity there, certain things that alone cannot be the basis for placing somebody under an emergency detention order. Here we have epilepsy, dementia, substance abuse, and intellectual disability. It doesn't mean that they cannot be alongside another diagnosis, but standing alone, we can't have just one of these items here. And when we talk about risk of harm to self or others, when we're talking about physicians and talking about adult community members, we're basing it on personal observation. So what is happening in front of that physician, that family member, that they're seeing, that the person is doing, what behaviors are they exhibiting, and context is really key here when we're talking about these personal observations. This is a favorite example of a colleague of mine really honing in when we're describing what's happening with an individual, it really is creating the context. Really, well, this was supposed to pop up so y'all could guess, but all the answers are already on the screen. What is really the purpose of these emergency detention order? And to put it very simply is that we're looking to get an individual an evaluation. That evaluation will determine whether or not the person needs further assistance and if that needs to be done in an involuntary process and through a court mechanism. The duration, there are some nuances here I'm not really going to go into at this time, but generally we're looking at a 48-hour hold that we have here in Texas. Could be, depending how the statute is written, sometimes it's a little bit more than 48 hours, sometimes it's a little bit less. And really, if needed, there could be a second EDO if time runs out. But the real point I want to drive in is if we identify someone who needs further assistance or involuntary treatment, really getting them to the next stage of the process, what would be that OPC or that protective custody order. So here I want to turn it over to Dr. Kutcher-Diaz. For me, I've got applications that come in. I screen them every day for people who are potentially going to be placed under emergency detention order. I screen the paperwork. I look at what's happening with the individual, the legal criteria. It's sent over to our judges. They make the final call. But I want to step behind the curtain and ask Dr. Kutcher-Diaz what's happening on his end when he's at our state hospital in El Paso, the El Paso Psychiatric Center. He's in the inpatient setting. What's happening when an individual is possibly going to be placed under emergency detention order?
Thank you so much. So, talking about the emergency detention order and the civil commitment process in general, I'd like to clarify one thing. These, situations are reserved for our most severe cases. I worked at the Texas State Hospital in El Paso, so these are people who have little to no resources, maybe don't have family, maybe don't have reliable identification. A lot of the time they're homeless. So this is something that's very, these are again just the most acute cases you can see, right? So, for example, when I'm at the inpatient psychiatric facility, usually if I receive an EDO, as Ms. Chisolm had mentioned, it would be, say for example, a family member brought them into the hospital, and there's context is key, right? So it's not the same thing as if somebody comes in voluntarily to the hospital, because that shows some level of insight, which is important. That means they understand they have a mental illness and they understand that they need the help. Now, say for example, if somebody is brought in by, a family member, that raises a red flag. That means that somebody had to stop whatever they were doing that day to bring that person into the hospital. Now, what raises the biggest red flag is when a police officer brings them in, because that says, one, they could have gone into the criminal justice system. They could have caused harm to themselves or somebody else as a result of their mental illness. So in those particular cases, right, again, it's very important to understand the context, and that alone is a big flag that you have to look at. Now, when it comes to emergency detention orders, sometimes they'll come into the psychiatric hospital seeking help, but I don't really feel comfortable just, letting them leave. And a lot of the time, when they're there, they don't feel, sometimes they'll second guess themselves. They'll be like, you know what, I don't want to be here, right? The door shuts behind them and I'm like, oh my God, I'm incarcerated. You know what I mean? Like, it's really, and it's understandable. Being at the psychiatric hospital is a scary place. Nobody wants to be there. Nobody wants to be in any hospital, but psychiatric hospitals in particular can add an even higher level of, frightening, right? So one of the things that I do is I talk to them, and you do have to let them know that some of the things that what we discuss here is confidential, except in the circumstance that I'm concerned for your safety or the safety of somebody around you. Is that okay with you, right? And that's where say for example, they tell me something that seems out of the ordinary, right? They're telling me that they feel like aliens are watching them, but they don't feel like killing themselves. Well, that's a little odd, right? And they give me a phone number to contact collateral, and I can't find them, or the phone number doesn't work. So in those cases, I file an emergency detention order, and they might say, well, I want to go home, I want to leave right now. But I let them know that just given the circumstances, we want to make sure that we have a safety plan in place. Usually, if they want to harm themselves, it's when we for sure file the EDO. But certain circumstances are important to recognize. So we file the EDO, they remain in the hospital, and at that point, a first CME is filed. Now, the first CME can be filed by any physician, but Ms. Chisolm will go into that as well.
And here the PowerPoint will be available I just wanted to briefly go through some of the forms that we use out in El Paso. You may have them a little bit different, but essentially, just for the police officers, the peace officers, this is a sample of a notification of detention form that they're presenting to the hospital when they're bringing an individual in. Again, it is that, a notification, just letting the facility know this is what happened, this is the reason, and then they're going to turn the patient over to the facility so they can then do the evaluation. And here again, just what is a physician defined here in Texas? And you'll see there we've got our residents. And then this is the form that Dr. Kutcher-Diaz and his colleagues would fill out, or physicians would fill out, that we use for our emergency detention orders, just so you all have a sample there. But when we're looking at it, we really have to make sure that while the clinical side is they're looking at how are we going to treat this person, what is that plan going to look like, on the legal side, we really need to make sure, and the judges are having to really see that there was the legal standard that was met in order to use this hold. Because again, this is a legal mechanism, but it needs to be used in situations where it's appropriate. So again, this is just sample forms that you all can see if you'd like, of how we submit our paperwork. We have a specialized mental health unit in our county attorney's office. We have the process kind of down like clockwork as far as getting this to be as efficient as possible, because we are under a time, ticking time as to how much we have to work with a case when it comes in. So very fast paced. But getting back to the actual process, so we've got somebody who's now, for example, at the El Paso Psychiatric Center. Dr. Kutcher-Diaz has filed the emergency detention order application. It has been granted. And at this point, from that evaluation, the doctor has said, yes, I've identified that this person does need further treatment, and at this point, for a variety of reasons, it cannot be on a voluntary basis. So we're going to go to the next step of the process, which is going to be applying for application for temporary inpatient services, and also for an order of protective custody. What we're saying is, essentially, judge, we need a court date, and while we're waiting for that court date, can we please, we're asking the court to hold this individual here pending our court date, which makes sense. If we're talking about somebody being a risk of harm to self or to others, we wouldn't want to discharge them from the hospital in that state of being without any treatment, and then ask them to come back to a court hearing that may be some days later. So those what happens on the legal side. The application goes in, but what I need with that application is I need a certificate of medical examination filled out by a Dr. Kutcher-Diaz, or in Texas, we can have any physician fill out these certificates of medical examination. Once that's submitted, again, it's going to be sent to with the court packet for it to be part of the information that I introduce into my hearing, and we get a hearing set. The way it works in our probate court back in El Paso, we have our hearings every Monday and Thursday. So we've got 72 hours between each court hearing. So if someone is going to be having their first court hearing on Monday, their follow-up court hearing would be on Thursday. So I'm going to turn it back to Dr. Kutcher-Diaz so he can share with you all what is happening in the hospital setting when he has now been alerted, or he has made the decision, this person, we do actually need to go forward to court. Voluntary is not going to be an option. We cannot put them into an outpatient setting at this time. So what is happening with Dr. Kutcher and his patient at that time?
So as Ms. Chisolm mentioned, right, when it comes to the EDO, we're just raising that initial red flag. I don't think it's going to be safe for them to go home in the state that they're in. Once that process is done, then we go into the first certificate of medical evaluation. So any physician can file a first CME. Now, the reason why it's important to highlight that any physician can do this is because it can bide a little bit more time in certain situations. So say, for example, if a patient is in the emergency department of any medical hospital out in the community, right? Those physicians can file a CME with the understanding of what needs to be met, right? So for example, if they can really show on that document that they talk to the patient and they have, for example, suicidal thoughts with an active plan, there is no safe discharge plan at this time, then they can file a first CME and then, they can help us get them to the psychiatric hospital. But for the sake of argument, here we're putting it in the context of them arriving to the psychiatric hospital with the EDO already accepted. Now, when they're in the hospital, I conduct a full psychiatric evaluation when they're there. So that would include, getting their history, why they're there, what's been going on for the past weeks, months, days, and get a feel for exactly what's happening, and also go into what is their past psychiatric history. Do they have any diagnosis? Have they seen a psychiatrist? When was their last appointment? Have they been using any substances, right? And that gives us, a bit more insight into the risk of harm and the danger of deterioration. On top of the psychiatric evaluation, there's what's called the mental status exam. When I'm talking to the patient, we're looking at their appearance. Are they disheveled? Are they malodorous? Does it seem like they're groomed at all? With regards to their behavior, are they fidgety? Are they cooperating? Are they guarded? Does it seem like they don't want to be there? And obviously, most of the time they don't. But with regards to their speech, are they talking, like 1,000 miles an hour and you can barely make out what they're saying? Are they yelling in the middle of the interview? With regards to their mood, are they saying they're happy but literally tears are streaming down their face? Their thought process, right? Are they disorganized? Are they able to put a coherent thought together, a full sentence together, in a way that makes sense? Are they able to stay on topic rather than, veer off into something that's completely unrelated? Or will they, talk for 20 minutes, and go around and just talking about everything before answering whether or not they ate yesterday, right? Which can happen, right? So, and finally, right, insight and judgment, right? Now, insight and judgment are things that you can infer based on the patient's behavior, but those are things that you can also directly ask, with formal questioning as well, which is important to recognize. Now, when it comes to the first certificate of medical evaluation, right, I put down what I see, the things that I feel like are important to highlight. So if they tell me that they're suicidal, that's going to be very much highlighted in, that evaluation, right? Another thing is things that describe their behaviors, right? So things that are in our mental status exam. What are they doing? Did they flip a table? Did they throw a chair, right? And then at the end, I'll place my assessment as to why I feel that this person needs to stay in the hospital until they need further treatment or observation. So the main thing when it comes to the first CME is to say, well, I need more time. Maybe I don't feel like there's a good enough discharge plan. Maybe I have a treatment plan in place, but we need to see whether it's going to work or not. And maybe they're still acutely suicidal, and we really don't feel like they can go home right now. Now, when it comes to turning in these CMEs and EDOs, we definitely rely on the help of people like Ms. Chisolm. In my particular case, I work closely with Mr. Michael Gomez, and they really help us out to learn how to draft these documents, because these are legal documents, right? And a lot of times we'll use medical jargon as if everybody understands what we're saying, and really that might not be the case. We really need to break things down in a way that everyone who's reading these documents can understand. And that's where, when I first started in my residency, I was turning in these evaluations and I would get them back and I'm like, can't you see? I just said they want to kill themselves. But, the thing was that sometimes with the way that we word things can make things seem like there's like a gray area there, right? And so with the help of people like Ms. Chisolm, who works closely with the residents at Texas Tech, they help us gain that understanding as to how to draft documents appropriately, which of course lawyers are well trained in, right? So it's something that really is a huge benefit for me and my colleagues when we're in this process, okay?
He said very nicely that he needs to dumb it down for us lawyers, which is It's the truth. I mean, when a clinical language and legal language is very different, and sometimes that in itself can be a barrier. Part of this partnership and trying to engage our physicians, our residents, the individuals who are using these legal mechanisms is to bring them into a space where the legal environment makes sense to them, so that they can clearly tell a judge or they can clearly do an application that allows for an individual to receive treatment in an appropriate situation where they are finding themselves where they are risk of harm to self or others. But this next are the process after we get the CMEs in, and here's just a sample of a document and what Dr. Kutcher-Diaz or another physician has to fill out. We get to what's going to happen next. At this point, the patient of the hospital now has an attorney ad litem appointed to them. They have legal representation that's going to meet with them, conference with them, figure out what they're going to do in the first court hearing. I'm going to have to prepare one of my witnesses, usually the physician who filled out the certificate of medical examination. This is where it's not as fun for the residents. They're thrown into this testifying process very early on in their residency training. And what I was seeing is prior to taking this role as assistant county attorney, I was on the other side of the law. I was the attorney ad litem for these patients going through the mental health system. And what I kept seeing, and I kept getting an incorrect perspective that I now understand, is it seemed that when these doctors were testifying, that they didn't really care about the patient. They were there and maybe not as familiar. They wouldn't say much in their testimony. And it would really frustrate me with my client sitting next to me. This is a hearing. I want everything to be out there. I want all the information. I want my client to have a great and proper hearing. And it wasn't until I switched roles and came onto the side of being a prosecutor and started working with these doctors that, in fact, like many other times we've seen, is somebody we may perceive as a barrier is actually somebody who also cares about the same population that you do, who also wants to provide the care, who's also looking at that person and how they can help them. So that was one of the best misconceptions I was able to detangle by working these processes with the physicians and in these trainings. But in the legal process, we then have a court hearing set. We've got our judge who's going to hear the case and make a decision. I've got one of the physicians who's going to put on some testimony. There's an attorney ad litem who's going to put on any defense for the patient that they feel is important and relevant. And at that point, the judge is going to make one or two decisions. Either, nope, there is not probable cause and the person is going to be discharged from the facility. They're going to go back to the community. That's it. Case is over. There's no ad litem. Everything is finished up. Or in the other hand, the judge is going to make a decision. Yes, we're going to go ahead and find that the probable cause was met, and we're going to continue to hold this individual for an additional 72 hours to get them into their final commitment hearing. So this is where I'd like for you all to get some exposure to what's happening with a doctor that's testifying on the stand. I know that sometimes lawyers, we have this vision of psychiatrists, what they may or may not be doing or not doing, as I had as a defense attorney. But it's what I found, at least, was that there is so much nerves and uncertainty in a legal environment that it was preventing some of these physicians from being able to clearly express in the legal setting what is happening with an individual. So with some training and some resources, it's seen a dramatic change of what's happening in the testimony. But I'll let Dr. Kutcher share his experience, which I think he still has a little bit of not good thoughts from his years of.
All too true. No, just kidding. So when it comes to the legal process, right? Again, this is something I had no idea about, and when I first started, one of the first things the ad litems would do is they would, ask me what makes you an expert witness in so many words. And at first thought, I'm like, I'm a doctor. I went to medical school. I'm here. Like, what's going on, right? And it's something that really, first off, you all of a sudden somebody's questioning you in a way that you've never been questioned before, and understandably so, right? Because this is a legal process, and you want to make sure that all of it is documented, all of your credentials, all of your experience, all of your expertise. And it was something that was very daunting to me. From the moment that I raised my right hand and was sworn in, like I said, I felt like I was thrown into the wolves. I was like, I don't know how this works. And there were times where I would testify and one word answers, that's all I could think. Yes, no, yes, no. And if there was anything else, they would have to ask it specifically. I remember, I think one time ad litem asked me, has the patient done anything that would state that they are at risk of harm to themselves? And usually, when somebody asks that, I'm sure that they would typically expect to say, yes, this is what they did. But all I said was, yes. So there's really, I told myself, just keep it simple, answer the questions as they're asked, which is something that had helped me in those times. And so when I was there, one of the things that I thought about, right, was, what is the other side looking at as well, right? And looking at the patient's perspective. And I think it also made me grow. Why? Because I thought to myself, if I were in a psychiatric facility and I felt like my rights were being taken away from me unjustly, I would be ecstatic to see my lawyer, somebody that's there for me and advocate for me, right? So at first I was like, what are you doing? Like, you're going against my recommendation, right? But at the same time, I do understand, where both parties are coming from. And at the end of the day, I know the ad litem wants what's best for the patient. The question is, how much information does the ad litem have versus how much we have, right? So usually the way PCOs go, at least in my experience, is, we're just requesting more time, Your Honor. If you write a good enough CME, the judges will usually grant it. Sometimes the patients will speak for themselves and they'll be like, okay, PCO granted. And so sometimes, that also helps to get the process of going along further. Now, when it comes to the second CME is kind of like where things, start to get a little bit more intense when we're looking at the final hearing, right? Because that's where you really, as a psychiatrist, you really need to be prepared, because you're going to be cross-examined. They're going to ask you questions about everything that's going on. And so, before that, right, comes the process of actually filing the second CME. So the second CME is something that has to be filed by a psychiatrist, right? So say, for example, I'm one of the physicians, what we call on the floors, and I'm treating this patient for an extended period of time. I'm the one that typically files that second CME, right? Now, that second CME, I'm doing the same thing. I'm doing a full psychiatric evaluation of that patient in that time. Now, I'm also taking into account what I've seen in the time that I've treated this person as well. So all of that to write that second certificate of medical evaluation, that needs to be robust so that the judge will say, well, we definitely need to have a hearing about this, right? So once we hit that court date, which is when we, after we submit it and it's been accepted by the judge or the magistrate, then usually they'll let us testify, right? And at the final hearing is where, like I said, things go along a little bit. They're a little bit different, right? Because again, you don't want to be prepared, you want to be over prepared, right? So for example, when I would, prepare for court for that final hearing, I know this is no small thing. When a commitment is done, I know what it means for a person's record. I know that this is something that I don't take lightly. This is something that I feel like is very much needed. Otherwise, for example, I've seen patients that, in a manic or a period of schizophrenia will start knocking on random people's doors, going into people's houses, just acting bizarrely, and there's guns in the house. So I'm thinking long-term of what might happen if we don't intervene now, right? And I try to make that abundantly clear. So regardless, my testimony is based on what I'm seeing then and there. So I know when I'm at that on the stand, I know exactly how much of the patient's meals they've eaten. I know how many times they've showered. I know, that they've been monitored for any episodes of aggression, how many emergency medications needed to be given as a result of them becoming violent in the units. And I need to come prepared with that, because I know that the attorney on the other side is coming, they're always coming with their A game, but this particular time even more so, right? Because, a lot of the patients don't want to be committed, right? So Once that comes around, we request, for a commitment for 45 versus 90 days. Why is it 45 versus 90 days? Because that's what the law says, right? We can only request for 45 or 90. There's no real data to state that, that 45 days is the perfect amount of time or 90 days is the perfect amount of time. Usually you want to bide as much time as you can because, for example, you request 90 days and they do better after 60. You can convert that inpatient commitment to an outpatient commitment. That way, once they leave the hospital, they're also able to get resources to make sure that they're going to their appointments, to make sure that they're taking their medication, and we can avoid this altogether. So in essence, right, it's something that you want to make sure that you conduct yourself in a way that you know what you're talking about and you know what you're doing. Deciding whether or not to admit a patient is not the hardest part of being a psychiatrist. Really, it's the bare minimum you should really know. And to not understand this legal process, right, it's much in the way of like, this is my operating room. These are my most acutely ill patients, right? If this were, if I were a surgeon, these would be patients with gunshot wounds, car crashes, right? And that hospital is my operating room. The only way that I have access to that operating room with a patient that does not want to be there is through this legal process, right? To ensure that they get the treatment that they definitely need, regardless of whether or not they truly understand that they need it, right? So I think that more or less, sums up my experiences, within being, giving testimony in the courts. And again, thanks to people like Ms. Chisolm, Mr. Gomez, I've been able to learn the dance, so to speak, because that's how it feels. It feels like I'm going into the courtroom and everybody knows the steps except me, and then everybody's telling me, well, look at this guy with 2 left feet, right? So really it's something that I think is essential, right, for every psychiatrist. So.
He covered my legal part, so no, that means I've trained and worked with him well. But just turning back to the court process, like Dr. Kutcher-Diaz said, we're getting ourselves to the second court hearing, which may be at that next setting, or the law does allow for that case to be continued if there's a good cause that the judge sees, and we can continue up for a 30-day period. But if we find ourselves in a situation that we are going to go forward to a commitment, then we're looking at that 45 or 90 days. And I do want to emphasize that I am not in the business of committing our community members. That is not something I go out and I think I need to win these cases and this is what I want to do is commit individuals. This is something that if absolutely necessary, we've exhausted all the other resources we have been able to use of stabilizing them during some of those continuances. And unfortunately, we do need to go forward to a commitment. Then at that point, I am calling my expert witness. I am having both of my CMEs that have been submitted, and I'm going to put on the case to help the judge see the facts of it. They can decide yes or no, this individual does need to have that involuntary commitment. With that being said, I really, by being on both sides of the law, it's very important to me that this process is done with a lot of respect and compassion for my fellow community members. This is not something that I try to make as non-adversarial as I possibly can with the attorney ad litem. Everybody has a different role. Everybody needs to stay in their lane and make sure they're carrying out their role. But there's a way of going about being an attorney that we can tap into and give ourselves permission to be in these court settings, specifically in the area of mental health. We can allow ourselves to be able to ask the questions to our witnesses in a way that is causes as least harm as we can to the patient who's in the room, that individual, that community member that could be a brother, a sister, a mother, father, et cetera, in a way that carries out the job that we need to do, but also remembers that this is a human being and connecting with that human aspect that we have. So I really just want to emphasize there are so many ways that we can lawyer, and I think especially in anything dealing with mental health, it's very important we give ourselves permission to have those parts of us be present in our toolbox as lawyers. But with it, again, we have 2 decisions that could be made here. Judge says, nope, sorry, Ms. Chisolm, didn't make your case. Evidence isn't here. The patient will then be discharged from the hospital. The case is dismissed. Or we're going to have the opposite result. Yes, we'll go ahead and grant the case. The person is then committed for the 45, 90-day period. And at that time, the proceeding is over and it turns over to the treatment of the psychiatrist and in the clinical setting. The court process is concluded unless we at some point during that treatment, there's been stabilization to a degree where the doctors are indicating we'd like to come back to court and we'd like to modify this court commitment so this individual still has the commitment order, but on an outpatient setting. So they're ready to step down to an outpatient setting. However, we would like to utilize the court order to have there because there's been maybe some inability or some difficulty complying with voluntary or following up with the outpatient services once they're discharged from the hospital. Another reason that we may go forward with a commitment is if somebody has been refusing their psychoactive medications and they need to have those administered. Again, this is something I really try to do at the very, very last resort if we have to, and that's because somebody has been refusing their medications, they're deteriorating, they're not doing well, and the recommendation from the clinician, from the psychiatrist is we need these medications in order to help this individual, and this is our last resort. And again, we have wonderful judges that will talk with the patients, try to admonish them. The ad litem's will try to work with the patients first to see if we can avoid this. But at sometimes we do have to go forward, and we can only go forward on a petition like this if we have a commitment in place. So we do those hand in hand. We can also modify the judgment as well, like I was sharing with you, from inpatient setting to an outpatient setting. And another concept and program you all may have heard of by this point is an assisted outpatient treatment. This is a wonderful outpatient program that individuals can get into that provides more support and services for those people who have had difficulty for a variety of reasons being able to follow up with their outpatient services on a voluntary basis. If you don't have an AOT program or you haven't heard of it, please let me know. It's a wonderful resource. It has helped so many of our community members get out of that revolving door of coming into the hospital, getting stabilized, discharged, and then unfortunately finding themselves back in an inpatient setting, or unfortunately sometimes maybe even in a jail setting. But this is the walkthrough we have. Mostly, I just wanted to give you a different perspective of what's happening in our hospital setting, what's happening with our clinicians, our psychiatrists, our doctors. I'm going to open Dr. Kutcher-Diaz up for questions, just him. No, you can also ask any questions to me as well. But I really want to extend both of us as a resource for you all. This was a very generalized and light walkthrough of the civil commitment process. There's many nuances that go in, and there's different things to consider with this process itself. But please feel free to reach out. I'm more than happy to assist in any way that I can, or just hear what's going on in your community that maybe we should have out in El Paso as well. If there's any time for questions, I'd like to open it up, and also thank JSMH for graciously having us and offering this opportunity.